The Judicial Council has made it very easy to ask form interrogatories, and it is possible to complete them in approximately 4 minutes if you are familiar with the questions that are being asked. So, what did the Judicial Council do to make it easy to respond to form interrogatories? I'll give you a hint. Absolutely nothing. When responding to form interrogatories, your response must be in writing. There is no Judicial Council form. Instead, you typically respond on 28-line pleading paper, which you can create in any word processor or using the template accompanying this presentation. If, however, you cannot create pleading paper for some reason, as long as they are otherwise formatted properly, they are acceptable. Your answers must be numbered and given in the same order that the questions were asked. This may seem obvious, but if you've ever read your car's owner's manual, you'll notice that there are many, many ridiculous-sounding warnings in there. For example, do not attempt to operate your vehicle while you are sitting under it. Things like this. Well, each of these stupid warnings is an epitaph to a stupid person who tried it. Each of these rules that are obvious like this in the law is commemorating a particularly obnoxious attorney that decided that they'd try to make life difficult for the other side because they weren't expressly prohibited from doing so. So just remember, your answers must be numbered and given in the same order that they are asked, and they must be verified, meaning you've got that I declare under penalty of perjury under the laws of the state of California that the foregoing answers are true and correct language above your signature line. Like any document on 28-line pleading paper, your name, address, and telephone number appears at the top, and then where it says defendant in pro per, change it to defendant or plaintiff depending on who you are, in pro per. The name of the court goes again on line 8. Above the words plaintiffs, write the name of the plaintiff, where Acme Inc. appears, and replace Paul Sample for defendants with the name of the defendant. Replace the case number with your case number. The title of the document is changed to defendant if you're the defendant, plaintiff if you're the plaintiff, your names, response to plaintiff if you're the defendant, defendant if you're the plaintiff, their names, form interrogatories, and you can follow this with the type of form interrogatories such as general, limited, civil case, etc. And then set number starting at 1. Right below the caption, the propounding party and responding party are again identified, as well as the set number. And then it's followed by responding party hereby answers propounding party's form interrogatories, and then for each item that you're responding to, you're going to create a numbered response, skipping over and ignoring any of the form interrogatories that were not checked. Form interrogatories in a limited case are fairly self-explanatory and simple to respond to. You read the interrogatory and you respond to the question. In an unlimited case, however, where the interrogatories frequently have subparts, there are several different ways that they can be responded to. First, you could respond to the entire question in prose as a paragraph. You could respond to the question very Spartanly by mirroring the format of the question. So, for example, Form Interrogatory 2.3 states, did you have a driver's license at the time of the incident? And then it asks for the issuing entity, the number, the date it was issued, and any restrictions. Well, you could respond, yes, A, California, B, and then a number, C, a date, and D, any restrictions. Well, if you did this, imagine that you've been responding to discovery for about 10 hours and your eyes hurt, and now you're going back to proofread. If the only thing that you have staring back at you from the page is the word yes, it's hard to know whether or not you responded to the proper question. For example, there is a big difference between responding yes to yes, I had a driver's license, and yes, I've been convicted of a felony. Because of this, I like to put a little bit of extra language in there describing the question. So, for example, yes, I had a driver's license at the time of the incident. The reason I'm doing that is so when I'm proofreading, I'm able to see that I've answered the right question. Because if I read the question and it says, have you ever been convicted of a felony? And the answer says, yes, I had a driver's license, I'll know that I've misnumbered my questions. Even better, If for some reason this slips by me in proofreading, the other side will know as well. Now, the other side may have a small army of flying monkeys doing their typing for them, in which case they may actually type out the interrogatory in front of the answer. This is useful for the same reason, to make sure that the interrogatories are corresponding to the answers. However, it is not necessary. The only requirement is that your response be written and that the answers are numbered and in the sequence that they are asked. Finally, at the end of your page, be sure to have the "I declare under penalty of perjury under the laws of the state of California that the foregoing answers are true and correct" language above your signature line. Form interrogatories are immune from objection on the basis of their format, meaning that the format of the question has already been approved by the Judicial Council. It is possible, however, to object on the grounds of content. And the format for an objection begins, "The responding party objects on the ground that," and then the basis of the objection. So, for example, the objection to 12.2 would be, "The responding party objects on the grounds that this interrogatory violates the work product privilege." One thing you should be aware of when you receive responses from an attorney is that it is possible that they may object to almost every single interrogatory or other discovery request that you receive. However, they are merely preserving the objection and will typically follow their response with, "Without waiving said objection, the responding party would answer," and then the answer to their question. It is possible for you to do this as well. However, keep in mind that if there is a motion to compel filed, based upon an objection, and the court finds no reasonable basis for this objection, the court may sanction you for abusing the discovery process. Notwithstanding this, once you have completed your responses, make a copy to keep, and then have the propounding party served with the original responses and a copy of your proof of service if served by mail, retaining the copy of the responses and your original proof of service. If any other self-represented parties or attorneys are in the case, they are also served with a copy of the answers and a copy of the proof of service.